It's fine.
Yes, ma'am. Yes, ma'am. Uh, Good evening to all in one present here, and a very good morning to Dr. Saira. Welcome to the session on global health law. Global health is the understanding of healthcare in an international and interdisciplinary context. It includes the study, research, and practice of medicine with a focus on the improving health and healthcare equity for populations worldwide. I think now is the time, given the ongoing coronavirus pandemic, to deliberate, discuss upon, ponder, and have a discourse upon global health law. In furtherance of this goal, we have arranged this session today as a part of International Teaching Month of ILNU, wherein we'll have two eminent speakers with us. It's my privilege to introduce you to Dr. Sarah Steele. Dr. Sarah Steele is the Deputy Director at Intellectual Forum at Jesus College, Cambridge, UK. She's also a senior research associate focusing on themes and problems of interest to communicate across the world at the interface of public health and law. And a senior, Dr. Sarah is an experienced lecturer and researcher specializing in policy and public health analysis, as well as in legal, qualitative, and ethnographical research. It's also my privilege to introduce you to Professor Dr. K.C. Sunny, Vice Chancellor of NUALS Kochi. Dr. Sunny has 30 years of experience as a teacher of Kerala University and the Central University of Kerala, out of which he has 11 years experience as a professor and 8 years as dean. After passing the LLM exam with first rank in the university in 1986, he started his teaching career at Kerala Law Academy and Law College. He has published the book Corrupt Practices in Election, and more than 45 research publications and papers are attributed to his name. He was the international observer to Nepal Constituent Assembly election 2006 and Bangladesh Parliament election 2007. He had delivered lectures in 16 foreign universities and had interactive sessions in 6 foreign universities, including the Harvard Law School. He served as the program chair of the International Conference on Law and Public Policy held at Singapore for 7 years. Before starting the session, I would just like to briefly introduce you to the session protocols. I request all the attendees to keep your videos on so that we may have a very interactive session with both these eminent speakers that we have on board today. And I also want any questions that you might have, you can directly address them to me, who is the moderator of the session, in the chat box, and I'll read the questions to both these speakers at the end of this session. Without further ado, I now would like to invite Dr. Sarah Steele to deliver her talk. Please, ma'am.
Hello all, just bear with me 1 second while I start my PowerPoint sharing. Apologies, there we go. So can everybody see the screen just to check? Good, perfect. So ultimately, global health law is something that I have been working with for many, many years, and it's become increasingly interested in and popular amongst students out of almost nowhere. Years ago, I used to have a small cohort of students, and this year I've had the largest ever. And I would say that is because for many, they would have said that 2020 and 2021 have been extraordinary times. We hear it so often, we hear it in the press. It's been an extraordinary time for us all. Unpredicted, it's moved legal and policy requirements in a different direction with the experience of the pandemic. But for those of us in public and global health, scholars would say almost quite the opposite. We'd point out to you almost universally that this was something that was entirely predictable. It was something we'd foreseen. It's something that we'd evolved legal mechanisms to try and deal with, albeit that many were untested and, as we'll come to discuss today, somewhat imperfect. We had, for many reasons, foreseen that a pandemic of this significance could evolve and present to all of us an issue of grave security, and also, most importantly, as I'll come to discuss, an issue for health equity everywhere worldwide. And certainly, one thing that I just wanted to say up front is, while I'll be discussing the contemporary legal mechanisms, I'll be discussing the future issues and future problems today, and I'll be setting out why this is a really critical issue for all students, be it if they wish to work in something like public law later on, or if they wish to specialize very specifically in global health law and medical law. those very specific fine points and areas, what I'm going to establish for you, I hope today, is that global health is now an important integral part of every one of our everyday lives. It's not something that, perhaps as I would have said a few years ago, was critical to know if you plan to work in international law and look at things like Ebola and things like that. Now, this is a salient, pertinent point for the everyday lived experience of persons around the world. As we evolve vaccines, as we debate and consider how they're going to be rolled out around the globe, how we're going to access them, how we're going to ensure equitable access that allows people, no matter where they are, to receive this very important option in their medical futures and their capacity to return to everyday life. It becomes a critical thing to discuss and debate the frameworks, the structures, the legal options that we have as an international community for assuring that health for all. And that's really what I want to unpick and discuss today. I really want to look at the fact that global health law is this kind of constellation of opportunities that we have going forward, and to discuss those, to reveal to you how you might respond to some of the debates and controversies by providing us a great future in this area of law. And in saying that, I just kind of want to emphasize that certainly law can act to create possibilities and to destroy them. It can build as much as it can break down and take away. And that's certainly true for health worldwide. Really, global health law can lead to health equity and justice, or it could move in ways that create vast chasms. It could extend the inequalities between rich and poor if we make poor choices in this field. And I want to look at some of those chasms that have started to emerge in 2020, 2021, and discuss the ways that law offers a possibility to bring us closer together and to ensure health for all, but also some of the pitfalls that we have learned about that we need to think about as lawyers going forward, and how we could change that at the international level. And so one thing that I want us to start from and remember here is that really we started with global health as an issue of international health or international health security. So international health, and where I want to begin, just to give you a little bit of a timeline and picture of what I'm talking about, because I know not all of you are familiar with this body of this constellation of provisions and discussions, as I've said. Some of them are very soft in their legal nature. Others do have a much harder edge, and we'll see that as we talk about some of the documents and how they're evolving in some of the treaties. But I don't want to underplay that this is a unique circumstance. As I said at the start, public health and global health specialists have been well aware for many, many years that epidemics exist. They happen frequently. They've happened for millennia. This is not a new experience that we're having per se. What is different is the capacity to travel rapidly, the reliance on international trade and manufacturing that mean that some places are not capable of supporting their people locally with what they produce. These things have left us with travel and trade that have made it critical, in fact, for us to respond. And that is where law has stepped in. International health was, as I say here, already a term of considerable currency in the 19th and 20th century, but it focused primarily on the control of epidemics across the boundaries between nations. Global health emerged in the last 20 years as a new terminology, really, 20 to 30 years to be fair to it, which in general sought to add to that notion of dealing with epidemics across boundaries, to look at whole planet health concerns, not just as concerns of particular nations, but as something that traverses those borders. The health needs of people involve the whole planet. And therefore, because we have that boundedness, that grouped together effect of these things being able to travel, as we have seen in 2020, around the world so rapidly, we need to look at this body of law as something that can respond to these crises as much as the general health of populations, to ensure that we can achieve equity and health for all people worldwide. So global health really emphasizes transnational health issues, determinants and solutions. It involves disciplines both beyond the health sciences and encourages and promotes interdisciplinarity. And it works quite importantly, and I think this is where it's really important for us to remember as lawyers, it works from the individual level all the way up to the population level, to the global level. And for that reason, it involves domestic provisions, local laws and governance, as well as international law in its response. And that's what I really critically want to point out here, is that this is a huge body of laws operating at different levels. But when we speak of global health law, it's important to remember that there are critical overarching principles and overarching bodies and overarching structures to which we need to turn. I will come to the core treaties in a moment, but I think for many of you, realizing the longevity of the history of addressing epidemics is really critical. For so many of us, we've felt like we're in a unique period, an unexpected period, something never faced before, posed by COVID. But it's important to remember that these pandemics led to international legal responses for a very long time in all their kinds of forms, responses to cholera, to typhoid, to influenza. These things have long demanded legal responses. They've long demanded international political responses, and they've long demanded that states respond at a national level and communicate and participate and really work together to ensure that these pandemics didn't cross the globe with speed. And so I provide you here a timeline that gives you a sense of some of these core conferences, expansions, and agreements, the bodies that have been formed, and the partnerships that have evolved. I'm not going to dig through them one by one because of our timing today and how little time we have together, but I will, and I have shared my slides, and I'm very happy for them to be distributed more widely. What I want you to get, though, is really a sense of how much different, evolved timeline we are talking here. Some of the very important first public health laws of recognition were international in nature, these international sanitary conferences. And what they resulted in was a participatory system that led to declarations and partnerships that have spread throughout this new millennium. Here is but a few lists of the documents that those in the area seek to learn from, that build up this convention or body of law that we call global health law. These are not it in its entirety. In fact, global health law comprises of so many different things. You get in their human rights provisions, you get in their trade laws and trade provisions, you get these dedicated agreements on the environment, on things like mercury, on biosafety and biodiversity. And then you see them alongside the other issues that transverse boundaries, things like, for example, biological weapons, weapons of war like mines and their destructive nature, all of these sorts of things. And we get, of course, communicable diseases. We get things like venereal diseases amongst merchant seamen show up here as the subject of international agreement. And so it's really critical to see this body of law as something diverse, evolving, which I think is really important, and also something that across time will change in important ways to respond to the new needs technologically, physically, in terms of trade and travel of the human population. And so I'm not going to run through this historical evolution of this body of law, but I want to nod to its diversity, its complexity, and say to people that almost all of you, by the time you leave law school, will have interacted with some form of global health law, whether you like it or not as a consequence directly of the pandemic, which I'm sure will expand the spread of interest in this area, but as a result of this being something that shows up in international law, that shows up in public law, that shows up in trade law, that shows up in workplace safety, that shows up in human rights law. It shows up across a diversity of areas. And that's because global health law picks from each of these. And rather than being a central, directed, single body of law, it is a constellation of different instruments and actions, not enforced per se by an agency with policing capabilities or an army, but it's a network of treaties and bodies who partner and work together to negotiate options, adopt different approaches, policies, procedures, different requirements upon nations, and engage in monitoring and sharing of data. And really, that's the critical thing here. The really critical part here is that this body of law gives us an objective, gives us a normative standard, health for all, that seeks to build a better humanity. And I think that's the really critical aspect to this. And in that sense, it brings in a diversity of obligations, as well as a diversity of bodies and participants at various different levels. And I say here that this law matters for very specific reasons. Here is a beautiful table of just some of the human rights cases. And I'm just sticking to just the human rights cases alone. There's trade cases, there's a wealth of different case law here. But just to give you an idea of some of what these court decisions have led to, they've led to requiring governments to cover HIV treatment for persons in country. They've led to universal nutrition programs for children and young people. They've led to free treatment for people living with HIV, including universal healthcare in countries. They've led to protected water rights. They've led to upholding tobacco advertising limitations that reduce people's reliance on a highly addictive, highly lethal tobacco drug there. And then there is, of course, a whole bunch of different provisions that seek to address things like safe needle injecting and those things that improve the right to life of people around the world. And these are just a handful of the cases. There are so many more, and they're emerging day by day. We're seeing a flux of cases around the world of people assuring them their health rights, their access to various different forms of healthcare, no matter where they are in the world. And of course, there is the case here from India. So I know that after me, you will hear wonderful Indian perspective. So I won't go too far into that. But what I do want to emphasize is that around the world, in various different settings, global health law and those human rights provisions that attach to it, as well as the trade provisions that attach to it, and all of those requirements come to have a daily direct impact on individuals. For the person with HIV, for the person who may have taken up smoking, had they have had access to those cigarettes with all that packaging and advertising around it, to those people who need access to drugs or medicines, or pregnant women who need a safe and clean place to give childbirth. That's what this law seeks to achieve. And it really sits within something that many lawyers don't see. And this is something I have to say, I never saw this when I was a law student, but it is one of the most beautiful depictions of the social determinants of health. And we as lawyers so often forget these, whereas public health students see it in their first week of their first term. And I think we need to see it ourselves, to remember that law is critical to climate stability and biodiversity, to clean air, water, and land, to make sure our built environments are safe, are adequate, meet our needs, that they provide the capacity to work, shop, move, live, play, learn, all in these environments. And these layers that sit on this social determinants of health image really show us the layers of law that are needed to effectuate good global health. And that's what I think we often locate planetary health as this issue of the social sciences and physical sciences as something they do over there. And we're increasingly, as lawyers, recognizing that climate science and environmental law are parts of critical human life. And so one of the things that global health law now increasingly incorporates is something we call planetary health. And with that in mind, we have seen an influx and a change in the nature of things that we study when we study global health. It's not just down to medicine and health services. Global health is something much wider. It looks at mental health, non-communicable diseases, diseases like, for example, heart disease that flows from trade relationships that build a food system grounded in unhealthful foods and sugar-sweetened beverages that cause things like diabetes and the like. So we see these bodies of law expanding, and you can almost imagine this like an onion of different international and domestic legal provisions. But it's important to remember, and I think for all of you, one of the things that has really come out is just that prevalence and I don't think it's necessarily a good focus, but it's a necessary focus at the moment on communicable disease. As I'm sure you're all very much aware, the WHO has the constitutional authority here to negotiate minor treaties and soft instruments, including recommendations, and to set soft norms and various levels of institutional support to basically support the health of us all. That health equity aim that I set out is an aim of the United Nations. It's an aim of every country that signed on to those documents. It's something that's set out in our international human rights treaties. It's something that is really critical to remember. And the WHO has the authority to provide that soft law around that and to do various things to enter into force, various forms of regulations that are adopted by the Assembly that seek to bound countries to certain principles, action, and activity. And really, we have seen that in light of COVID. But what we have also seen and witnessed is that the WHO, quite frankly, lacks the enforcement ability, the capacity to enforce compliance. And thus, it relies, like many areas of international law, on domestic implementation, and it requires domestic laws, policies, and procedures to be followed. And it requires governments to meet their obligations by reporting and telling the world when they encounter things like this particular coronavirus. Certainly, almost all of you will be familiar now with one particular thing in the WHO's ambit, which is the International Health Regulations, which were adopted by the World Health Assembly in 2005 in the aftermath of the first SARS epidemic. The aim was, of course, to enhance monitoring and to allow for the reporting of any international threats. This really was an idea that we could have a coordinated response internationally to any of those diseases, or it does encompass much wider things. It's not just communicable disease. It covers things like biological and chemical threats, all of those things that traverse borders. We really need to remember. It happens that this has been a coronavirus, but it does have wider implications. But the overall aim of that was also to allow a response that didn't unnecessarily interfere with traffic and trade. The idea of these regulations was not only to give us an adequate health response, but to protect and promote freedom of movement and also the economies worldwide. It provided a decision instrument to guide governments to monitor health hazards in all their forms and ask that within 24 hours, those that could constitute a public health emergency of international concern would be reported and responses could begin. As I'm sure you're aware, in late 2019, cases had been observed and notified. And between December 2019 and January 2020, China showed great transparency, to be fair, around epidemiology and genomic sequencing, allowing the WHO to investigate and respond. And on the 30th of January 2020, the WHO's Director General declared what we call a public health emergency of international concern under the IHR. I would note that this came with only 6 public health emergencies of international concern, having previously been declared across the preceding decade. And we very quickly saw the implementation of policies under Article 43 of the IHR around the world. Here is a really nice diagram of this. The idea here is that threats have no borders, so therefore we need to protect travel and trade, and we need to enhance global security to ensure that threats are kept under control for the benefit of all. This is the idea. This is the summary theory behind it, and Article 43 allowed to achieve those different aims simultaneously, arguably. But as you're also no doubt aware, there have been significant criticisms of this legal process. And I'm going to use these not just to highlight the issues here, in this specific instance, but also to highlight some of the issues that foreground our need to think about what global health law is trying to achieve and to explore its normative base, and to explore also what we do in the future and what we as lawyers should be thinking about. For one, if you followed any international press, of the criticisms about the process, that there was a lack of published transcripts and deliberations, that there was an either or decision. So it either is a public health emergency of international concern or it is not. The way the international health regulations are written, it's an either or decision. Many argued immediately after that we could have responded better. We could have had a capacity to move into a system that was tiered, where the second China notified, we came in here protectively, putting in place emergency protocols while we moved where this was allowed, that allowed us adjustments in light of evidence. As we came to realize that SARS-CoV-2 basically aerosolized, that it may pose particular problems in pregnancy. When we did evolve vaccines and we had a response to have that vaccine availability taken into account. Many were quick to criticize the structure, the direct writing of the legal provisions there, of the document itself, of the international health regulations. But there was also a debate about the WHO and its constituting aims and objectives and obligations. And many argued that it was pretty opaque, that there wasn't standard measures of transparency, that it wasn't something that had allowed for decision-making that was clean, that showed reasoning, that showed decisions, and also paid sufficient attention to whistleblowers, paid sufficient attention to international organizations on the ground, and paid attention to those around the world and how they were acting. Not just what governments reported that they were doing, but also taking into account the full breadth of people that could provide important information, including those of us on the internet. And one of the biggest criticisms here was that there was no inspections put in place. And there's also been very little follow-up on the capacity to have international independent review. That there wasn't sufficient attention to the fact that then President Donald Trump was able to point the finger and use China's response as a political tool. There wasn't an evaluation of the different kinds of evidence and shared knowledge that was publicly available. Countries were required to report as soon as they knew, but when did they know? There was different timelines and different suggestions put down about when doctors were flagging this on WeChat and Weibo and all of the socials on these wonderful devices in China versus when the report came. There was a range of different discussions about how the lack of an independent and the lack of a transparent body really stymied trust around the world. It really impacted on our perceptions and really embedded something we're going to talk about as I go on around a nationalist response. Sorry, this is not flipping forward. And really one of the other criticisms has been that we quickly moved into travel restrictions. This is a picture taken yesterday of all the countries around the world that have partially restrictive or totally restrictive travel requirements. When I first gave a version of this lecture back in early last year, this was a couple of countries shaded in the medium blue, very few countries shaded in the dark blue, and virtually all in that light blue color. Very quickly across 2020, restrictions on travel and trade emerged. And now, as we are in 2021, virtually the whole globe, barring but a handful of countries, has some form of restriction on travel and trade. And those travel maps here are really enlightening, especially when we consider the objective of the IHR was to continue that permitted movement, to protect it, and to minimize the disruption of these epidemics. And so a lot have argued that Article 43 needs to be revisited and explored and picked apart and discussed. So there's been a number of direct responses here by shutting down movement, requiring people to go into things like hotel quarantines that are vastly expensive. For context, you can probably hear I'm Australian. To get back to Australia at this point, it costs basically £13,000 for most of you to understand. That's almost what the average postdoc takes home for that entire year. And that has emerged through significant cutting of airlines and the requirements of isolation on return in a hotel setting. Now, a lot of people have been critical of these restrictions and the absolute closure of borders in some states. And they point to the fact that Article 43 says that any of these restrictions, any diversion from the WHO's recommendations, should be a direct response to the fact and must be based on available science, based on a risk assessment proportional to the risk, and reported to the WHO if they exceed the low threshold of delaying traffic or travel for more than 24 hours. Now, one of the criticisms that have come is that we aren't seeing these proportional measures, these proportional reporting of how we could have actually done this in a much more less restrictive way. So one of the arguments here is that there was less restrictive mechanisms available for many nations that could have been put into place that would have allowed ongoing travel throughout the period. But we don't know that. And that's one of the things that I want to point out here is that based on the available science, we have needed to gather that data. And there's been a lot of argument that that hasn't been done as efficiently and effectively with sharing around the world as could have been achieved. And part of that has further ingrained this nationalistic sentiment of we must protect those in our countries. We owe our citizens that protection. And that has now come to play out in what we've now termed vaccine nationalism, where a nation that develops a drug holds it tightly for their own population and doesn't engage in the sharing of that around the world as quickly and rapidly as they should. For example, I just want to give you the example, many people here are being immunized in the UK. Not a single person has been immunized where I come from. The state I have has yet to access the vaccine from where I'm from in Australia. My parents will not get the vaccine for a very, very long time. I probably won't see my own parents for years at this point. On the other hand, here, there's literally a vaccination center on the other side of this wall in my house. The hospital's right there and they're doing vaccinations. So there has been a real disparity. And my concern is that that disparity will play out in low and middle income countries and very low income settings in a much to further those health inequalities in a way that is fundamentally troubling and problematic. And it's troubling and problematic because 171 countries, of course, have entered a legally binding obligation under the International Covenant on Economic, Social, and Cultural Rights to take steps individually and through cooperation to realize the right to health and the right to enjoy the benefits of scientific research and its application without discrimination. So the availability and accessibility of vaccines of a good quality is thereby an obligation. We all hold, all the 171 countries that have signed this. But the focus to date has mostly been within states, not between them. Much of our discussion and much of our response has focused on how to equitably distribute healthcare resources within the finite resources we have in India or within our local government area. Here in the UK, it's been within our local government and nationally. We've set a tier ranking of who gets what when, but we haven't really discussed meaningfully distribution internationally. And we also haven't discussed the fact that non-communicable diseases continue to matter. They kill more people globally than COVID has, frankly. They're rapidly affecting low and middle income countries as we see health systems as well as, importantly, the health of populations outside the healthcare system directly being impacted by things like trade around increasingly ultra-processed foods, the plethora of countries that are now plied with high fructose corn syrups and high salt products and ultra-processed foods that lead to obesity, type 2 diabetes, heart disease, and stroke. They create the very risk factors for negative outcomes from COVID. And it's for that reason, I think one of my greatest points to public health scholars is always that there is an artificial division, both in public health and in public health law and global health law, between non-communicable and communicable diseases. We've always treated them quite separately. Communicable diseases get treaties. Non-communicable diseases are often an afterthought in equality impact assessments around free trade agreements and the like at a national level. Actually, one of my greatest arguments here is that non-communicable diseases are inherently fused to the communicable ones. They create the risk factors for negative outcomes, and they pose very substantial challenges for healthcare systems. And therefore, they are deserving of treaties and dedicated attention in their own right, as is mental health, which we've seen the ongoing challenge of, especially in countries like the UK, where I'm based, which have pursued lockdown legislative and policy approaches. But we also owe it to consider workplace conditions, injuries, and accidents. One thing that has come out of this pandemic is that while those in more privileged settings have been able to work from home, and we're sitting here on our computers, having the wonders of a lecture online, for many that hasn't been true, where there's been a rapid ramping up of production around things like face masks, medical devices, and the like. The people that are making those are exposed to some of the very worst conditions. Textile manufacturing, industry in the production of medical devices are concerned with human rights, labor rights, and many in the supply chain globally have suffered across this last year. The laws are often patchy, often largely domestic, and there's little international frameworks to date to deal with these accidents and injuries and poor work conditions. While there are those documents that cover human trafficking and cover labor exploitation, they don't cover necessarily the injury regimes and make sure we have an international agreement around those. They don't cover mental health concerns in a meaningful and robust way. They don't cover non-communicable diseases robustly and meaningfully either. So it's time perhaps to ask, is there a need to expand international health law to move truly to be a global health law and to look at international agreements on these issues? There are some things we've learned, certainly. I've played on some of these about de facto travel bans and things like that. But we need to think about how we recast our system. As I come to the end of our talk, I know I'm approaching time. I just want to kind of emphasize to you that we've learned a huge number of lessons, but I think one of the biggest lessons that I want to play home here is that we need to not narrowly focus on just health security. Health for all is our commitment, and it is important, and it involves well-being and a healthy, safe planet. And therefore, we should expect environmental lawyers, we should expect international lawyers, we should expect human rights lawyers, we should expect medical lawyers, we should expect those labor lawyers all to come together and to work effectively to address these future issues. We need to, I think about how we design greater transparency in decision-making at the WHO. We need to think about whether the system we had of a public health emergency of international concern actually worked, or if we need a more responsive, a more changeable system. We need to think about how we can foster greater cooperation in the face of things like misinformation and disinformation, and frankly, a growing nationalistic sentiment of racism and blame culture. We need to think about how we deal with unofficial data sources and independent investigatory bodies in responding to these issues. And we need to think about how legally we can respond to non-communicable diseases, workplace accidents, injuries, mental health issues, in a time where all eyes have largely been on COVID and communicable disease preparedness. In short, the question I want to ask you all is, how can we build a legal system that puts the world's health first? It's not an easy challenge to meet. And I think one of the first things we can do is break the dichotomy between global health law and public health law. Global health has traditionally been seen as an area of public health somewhere else. It's been concerned with what's happening over there that could pose a risk to us here. And that there and this here could be applied just about anywhere. It comes with hierarchies, it comes with expertise differentials, that we here have the expertise to deal with what's over there. And it comes with a normative basis that security is the issue. And there's a lot of those assumptions have been blasted through by COVID-19. And therefore, it's really important that we take this opportunity to consider the normative basis of global health law, to repurpose and redesign our tools and mechanisms, to think about treaties as well as these other instruments, and to bring global health law as a core into the legal curriculum as a local issue as much as a global one. To think about this as a critical issue of public law, as a critical issue of trade, to think of global health, to think of health for all as a consideration that we have throughout all of our legal studies, all of our legal decision making, and hopefully as legal practitioners, be it in government sectors, in private negotiations of treaties, to have that objective at the back to make sure that we are assuring it in all the practice that we engage in. And really, that's what I would encourage you to take home and welcome questions on.
Thank you so much, ma'am, for your enriching.
Thank you, Dr. Sara. It was indeed a very enlightening talk. There are so many issues that you have covered. Thank you so much. And now it's a pleasure to invite Professor K.C. Sunny with us. Professor Sunny is the Vice Chancellor of National University, Kochi, Kerala. Professor Sunny is an outstanding and visionary Vice Chancellor and has made a great progress of nuance after assuming the office. What I could learn from different sources that Professor Sunny is embracing the innovation in the legal education in a great way. Recently, we have come across the idea of gamification of the law curriculum. This is indeed a very amazing and innovative idea. Professor Sunny is also encouraging research in a great way and has been publishing books on the significant issues in the recent past. Professor Sunny and the Nuance has published books on different areas. So it's great to have you with us, Professor Sunny, and it's all pleasure. Please, I invite for you for your remarks. Thank you.
Respected Dean and Director, Institute of Law, Nirma University, Professor Dr. Purvi Pokhriyal, Dr. Sara Steele, Professor Alok Srivastava, Professor Shreya Srivastava, dear teachers and students, and other scholars present here. At the outset, I must congratulate Professor Dr. Purvi Pokhriyal for organizing this International Teaching Month celebration. Because teaching is very important for developing a society, especially for generating a manpower which is capable of catering to the need of the society. Today's session is on global health law. This topic has very great significance in the present situation, that is COVID-19, pandemic COVID-19. We have heard the presentation of Dr. Sara Steele, which extensively covered almost all issues. So, my presentation may be treated as 2 or 3 footnotes to the elaborate presentation by Dr. Sara Steele. I am not taking much time because I think nearly 273 participants, 273 73 students, experts, scholars, and other persons are joined in this webinar. So they may be interested in asking so many questions. When we are addressing the issue of global health law, I would like to refer the million bestseller Homo Deus, written by Israeli Professor Harari. In that book, Professor Harari highlights the fact that history of human beings is the history of plague, famine, and plague, war, and famine. Whether it may be plague, that is pandemic, whether it may be war, whether it may be famine, its impact on health is very, very important. And this impact may generate in the total disorder of the society. So it is essential to develop some international standards as far as the regulations in relation to healthcare is concerned. There comes the significance of this session, that is global health law. I fully agree with the view expressed by Sarah that there is no need for a hard and fast legal provision and a single implementation agency in this regard. We have to evolve certain norms based on negotiation, adoption, and monitoring. So definitely there may be some norms. When we are addressing the issue of evolving certain norms for the purpose of healthcare system, I think two aspects may be taken into consideration. First aspect is right to health as a human right. Right to health as a human right. I think nearly 70% of the nations of this world are already accepted these human rights standards, since they may be the party to the adoption of Universal Declaration of Human Rights, or maybe the signatory or party to the International Covenant on Social, Economic, and Cultural Rights. These two documents recognize right to health as a basic human right. So we have to approach this issue, that is evolving certain norms to ensure right to health to all inhabitants of this world. Human rights standards are very, very important. Second aspect is that we have to take into consideration of the role of the state in a welfare state, role of a nation. Almost all countries, I am not ignoring that, ignoring certain countries where military regime is existing. That is why I used the term almost all countries had accepted that constitutional democracy is essential to ensure basic rights of the citizens. Or almost all states have accepted the concept of welfare state.
Sir, sorry to interrupt. Kindly unmute yourself, sir. It's by mistake it was muted.
Okay.
Sir, thank you, sir.
Okay. In a police state, role of the state is confined to protection of the citizens from external aggression and internal disturbance. But in a welfare state, there are various functions to be performed by the state. State is a protector. State is an industrial manager. State is the dispenser of social services. State is the service provider. State is a regulator. When we are addressing the norms to be evolved to ensure health care, role of the state as a service provider may be specially considered. Then role of the state as a regulator is also specially considered. Coming to the first aspect, human rights standards, there are so many conventions. There are so many standards like highest attainable standard of health, then availability, accessibility, non-discrimination, physical accessibility, economic accessibility, affordability, information accessibility, acceptability. There are so many standards. Then there are certain standards which are prescribed for the purpose of the issues generated as the result of development in science and technology. We have Universal Declaration of Human Rights and Bioethics. We have Universal Declaration of Human Rights and Human Genome. All these things are not conventions, but certain standards prescribed by UNESCO. But these standards are very, very important. The issues like non-discrimination is specifically mentioned in all these documents. So we have certain human rights standards. And there are so many conventions based on these human rights standards. So many conventions have been referred by Professor Sarah in her presentation. So I am not repeating. So I am going to the second aspect, that is role of the state as a service provider. What is the role of the state in ensuring health care, considering that role of the state as a service provider? Coming to this role, strengthening a public health care system is very, very important. I am from the state of Kerala, where public health system is very, very strong. During this pandemic period, there was no need to bear any cost because free treatment is provided by the government. Government established temporary hospitals. Even the food is ensured at the time of this pandemic. So public health care, strengthening a public health care system, that is very, very important. We may remember that United States adopted the system of Obama health care, which ensured minimum health care to the have-nots, because there is no need to depend on the reimbursement provided by insurance companies, etc., etc. So there it is essential to strengthen the public health care system. That is the first point. Second one, we have to identify the role of the national government, if it is a federal government, the regional governments or state governments in the Indian context. Most important thing is role of the local bodies in ensuring health care. In my state, that is state of Kerala, in every local body, that is in every grama panchayats, there is a mobile unit for the purpose of health care. This mobile unit will work 24 hours. They will visit the households where there is at least one bedridden person every month, most probably every fortnight, to take care of their healthcare issues. So the role of the local bodies is very, very important. irrespective of the fact that whether it is a developing state or developed state, etc., etc. So this is very, very important, effectively using local bodies for ensuring health care. Then I am coming to the role of the state as a regulator. First thing is regulation of private hospitals and paramedical institutions. Because in a country like India, establishment of paramedical institution is quite often an opportunity for exploitation. At present, because in India, healthcare is a state subject. So it is a duty of the state government to enact law. But unfortunately, in most of the states, there is no serious attempt to take care of these issues, especially in the regulation of private hospitals and paramedical institutions. Second one, regulation of educational institutions, that is very, very important. In India, for medical education, we have so many deemed universities. If you go through the history of deemed universities, we can say that originally it was a medical college. Then they got the status of a deemed university. And in some deemed universities, all the institutions are related to healthcare, like the pharmacy college, nursing college, dental college, etc., etc. Then some deemed universities identify the fact that starting a law school, that is also very important for profit making, because for starting no law school, no investment is required. For starting a dental college, some investment is essential. For starting medical college, huge investment is essential. So there is no much investment. So let us start one law school. Let us start one business school. That is the approach. Anyway, regulation of education institutions for medical health care, that is very, very important. Then here, expansion, excellence, and equity should be ensured. But maybe the institution, whether maybe an education institution, whether maybe a medical institute, hospital, whether it may be a lab, medical lab, whether it may be a paramedical institution, whether may be an institution for medical research, expansion, excellence, and equity should be ensured. Expansion is in the context of the issues like this pandemic, etc., etc. Society is developing every day, so expansion is essential. That should be ensured. Then another important area is regulation of pharmaceutical industry. That is very, very important. I am not sure whether the legal provisions are sufficient for regulating our pharmaceutical industry in such a manner as to ensure equity, especially in the context of providing medicine with affordable price. That is very, very important. And I am not ignoring the fact that this pharmaceutical company may invest a lot of money. But in this context, we may remember that in the Doha Declaration, there is a categorical statement that if there is a conflict between human rights and intellectual property rights, human rights shall prevail. Human rights shall prevail. Then regulation of research, especially this regulation of clinical trials. In research and clinical trials, etc., etc., at present, the regulatory provisions are some guidelines issued by Indian Council of Medical Research, ICMR guidelines. I think comprehensive legislation is necessary in this regard. I am speaking in the Indian context. Then regulation of biomedical engineering, that is also very important. Biomedical engineering. Next thing is strengthening of grievance redressal mechanism. At present, we have consumer courts, but the consumer courts have its negative impact also. Because before starting a surgery, doctor or hospitals may insist certain consent letters. Then doctors may take all safeguards to relieve from the clutches of legal provisions related to this medical negligence. So we have to evolve some new grievance redressal mechanisms. So redress all stakeholders in the healthcare system. Now these nurses are underpaid. That is a well-known fact. So there shall be an effective grievance redressal mechanism for addressing the grievances of all stakeholders in the medical sector. Then another important thing is coordination of different systems of medicine. We have modern medicine, Ayurveda is there, Unani is there, Siddha is there. Now central government adopted a new policy of this encouraging this indigenous medicines like Unani, Siddha, Ayurveda, etc., etc. Ayush department is established. But generally this modern medicine people are deadly against this other systems of medicine, including homeopathy. Because during the pandemic, this homeopathy people and Ayurveda people are saying that yes, we have some effective preventive mechanism. But this system which is playing the leading role in the prevention of pandemic is controlled by modern medicine people. That issue is there. Anyway, a comprehensive policy is essential for coordinating different systems of medicines. That is very relevant in the Indian context. I think in the global context also, that is very important. Then regulation of preventive measures. Regulation of preventive measures. I think we have to evolve certain norms in this regard. With these remarks, I am concluding. I once again congratulate Professor Prof and Nirma Law School for organizing this International Teaching Month and arranging this session on global health law. Thank you very much.
Thank you so much, sir. Thank you. Over to Alokik.
Thank you so much, sir, and thank you so much, Sarah, ma'am. These were indeed not just words of knowledge, but they were words of wisdom, and I'm very sure that the students would be able to appreciate it. I now invite the floor, and I now invite the students to write any questions that they might have on the chat box. So I have one question from a second year student, Samson J. Kurian. He writes, thank you for an enlightening lecture, sir and ma'am. And this is a question to both sir and ma'am. Can you shed some light upon the limitations of poor nation states to fully commit to the idea of global health law? First, I would want the response of Sarah ma'am and then Sunny sir. Please, ma'am.
So I think the really critical thing is that because of the way global health law operates, because it's so diverse and involves so many different areas of law, the capacity to delineate where somebody's poor and somebody's rich is often quite difficult. So I'm going to just assume they mean in low-income countries as delineated socioeconomically there. And so one thing I would say there is that part of the normative base of this area of law of health for all is that obligation to ensure that across all settings, to knowledge share, to develop together our effective strategies and responses. While many of the preconditions that exist in low-income settings predispose populations to be particularly exposed to communicable diseases like COVID, actually some of the highest death rates have been seen in high-income countries this time. It's been the inverse of what we've assumed in many past pandemics. And so I think just speaking of high and low income countries and poor settings doesn't necessarily delineate anything around this particular current public health emergency. It does, however, give us a bit of pause and to think about how we share resources, what we share around knowledge and scientific endeavor, how we distribute and how we engage in making sure resources are equitably delivered. Certainly one of the big things that we're going to see in 2021 as a dominant issue is making sure that in those resource poor settings, people have adequate access to not just their healthcare systems for ordinary day-to-day health needs, as well as conditions like stroke and things like that, but also how we can get vaccines delivered in resource poor settings, how we can build trust in those settings in medicines when that trust has been so effectively eroded through things like social media and communication. One thing we saw when responding to Ebola, for example, was the capacity of digital technology of mobile phones to spread rumors, to spread concerns about the United Nations and other health organizations, to spread concerns about philanthropic bodies delivering vaccines, and therefore to lead people to be suspicious. They blocked roads, they raided cars and destroyed critical medical devices and medical products. They destroyed pharmaceuticals and things like that, and they eroded the capacity to deliver effective treatments, healthcare, etc. in those areas. So really one thing that I want to hammer home is that technology is fundamentally connected here, and misinformation and disinformation matter. But even more poignantly in those resource poor settings, it's trust and cooperation and partnership that need to be evolved really specifically to work. And in those low income settings, I think we haven't done enough. From the sort of privileged position I'm in here in the UK, I don't see the government here doing that kind of work in building trust internationally. And we do have some big issues around delivery of some of these vaccines. And I want to put it quite bluntly, not only are there legal mechanisms that create a real difficulty in exporting and importing the vaccine around the world, but there's very practical issues too for some of these vaccines. There's storage requirements, the fact they require sub-zero temperatures that can't be achieved in many resource poor settings. The fact that there's not the public health infrastructure in the countries where, and in the locales where they're needed to deliver those vaccines actually into arms. There are substantial issues that we face in poor income settings in delivering global health meaningfully to them. And the legal mechanisms around that are often quite prohibitive and limiting, as I said at the start of my speech. And we need to think about them and think about how we can change that and deliver on that normative principle, to deliver on that health for all idea, and how we can create a legal system that is enabling around the delivery of vaccines, down to the very pragmatic thing of staffing, the movement of healthcare personnel, training, cross-capacity training, and leadership. And I think that's it. It requires on all levels revisiting.
Thank you, ma'am. Sunny sir, we would now invite you for your responses on the question, sir.
Yes. When we are addressing the issue in general, that is not in the context of pandemic, I would like to mention three aspects. First thing is that the poor countries or undeveloped countries may strengthen their indigenous system, at least for the purpose of prevention. Each system or each nation or each part of the world has their own indigenous system. In Kerala, we have this Unani is there, this Siddha is there. So that system may be effectively used for the purpose of prevention. That is one aspect. Second thing is, there may be some insurance schemes meant for poor people, because government may pay the premium in such a manner. Some issues may be addressed. Last and most important thing is that even without the state, human beings survived for thousands of years by way of voluntary action and spontaneous nature health. That is very important. In this pandemic period in Kerala, I had the opportunity to see it. Government invited willingness for joining as healthcare volunteers for free service. The target of the government was 2 lakhs volunteers. But within 40 days, 2,20,000 people, 20,000 young people, that is between the age of 20 and 40. That range is prescribed. Volunteers, young people, express their willingness to join as volunteers. They are taking care of bedridden people. They arrange community kitchen for the purpose of supply of food. They are ready to cook and pack it and go to the house of the bedridden people through motorbike or cycle or through walking, etc., etc. So, as far as poor countries are concerned, voluntary action and spontaneous mutual help, that is also very, very important.
Thank you, Professor Sunny, for your response. We have one last question from Ginny Rajvanshi. She thanks, first of all, for an enriching lecture. The question is, how does globalization affect or will affect the health law and its contention in human rights across the globe, but specifically for the developing nations? I would invite Professor K.C. Sunny to respond on it first. Thank you, sir. Sir, if you can please unmute yourself. Yeah. Thank you, sir.
There is no need to stick on to the negative impacts of globalization itself. Globalization alone. There are so many positive aspects in globalization. But the basic issue is whether globalization is projecting the values of market. The values of market means make more profit. But in order to counter these values of globalization or values of market, not values of globalization, values of market, we have the values of human rights. So my point is that we have to give emphasis to the values of human rights in the process of globalization. That is evident from the incident mentioned earlier. That is this Doha Declaration. They are the basic issue that is in the context of compulsory licensing. We have now to say so many things. I am not mentioning all these things. Suppose there is a conflict between the values of human rights or human rights and intellectual property rights, which will provide? Human rights will provide. And we can incorporate the values of human rights in the intellectual property law also. Now there is a concept of semi-patents, then this free software, copy left, etc., etc. So what is important is in which aspects we are giving emphasis. We must give emphasis to human rights. Then there is there may be need to amend certain provisions, revisit certain agreements, revisit certain standards, etc., etc.
Thank you so much, Sunny, sir. We also have Professor Ricky Lee with us. We are glad to have you, sir, and hope you are doing well. We just had a morning session today in the morning with Professor Ricky Lee. So International Teaching Month was primarily designed to benefit the biggest stakeholders of academia, that is our beloved students. And I'm happy to share that the student community have showered their admiration to the various speakers that have been a part of International Teaching Month till now. To echo out their admiration, I now invite Ms. Niharika Harish Shetty, student of second year of ILNU, to extend the gratitude on behalf of the student community of Institute of Law, Nirma University. Over to you, Niharika.
Am I audible, sir?
Yes.
Thank you. Esteemed Dr. Sarah Steele, Honorable Professor Dr. K.C. Sunny, respected Professor Dr. Purvi Pokhriyal, our valued faculty and wonderful audience, it is my privilege to deliver the vote of thanks on behalf of the Institute of Law, Nirma University. I would like to express our sincere gratitude to our acclaimed guest speakers whom we are honored to host this evening. Dr. Sarah Steele has enlightened us with her insight in global health law, reminding us of its ubiquitous nature, how it permeates the bodies of law and touches people's lives. She has also drawn our attention to its dynamic nature, especially within the context of the world dealing with the coronavirus pandemic today, reinforcing the necessity of equality in healthcare for all people worldwide. Professor Dr. K.C. Sunny has also expressed his views eloquently on the importance of the state in ensuring a good healthcare system. He has also given us the Indian perspective, emphasizing on the need for regulation in different biomedical fields, as well as grievance redressal. Their words have left a great impact on us and hold true in today's socio-political landscape. I extend our heartfelt gratitude to our beloved Dean and Director, Professor Dr. Purvi Pokhriyal, for giving us this opportunity and platform to interact with the stalwarts in the field of global health law. I also extend our gratitude to Professor Ricky Lee for gracing us with his presence this evening. I must mention our deep appreciation of Assistant Professor Alokik Srivastava for ably moderating this session, and would also like to thank our administrative staff, Gagan sir, Ramesh sir, and Digant sir for their assistance this evening. This session would not have been possible without the tremendous effort of students and teachers alike, and I take this opportunity to thank everyone involved. Lastly, I would like to thank our wonderful audience this evening for being patient and participating earnestly, ensuring that this session is both successful and fruitful. Thank you all for joining us. It was an absolute pleasure to host you. Have a wonderful evening.
Thank you. Thank you, Professor Sunny. Thank you, Sarah. And we look forward to invite you and see you on the campus in future when everything is settled around us.
That would be lovely. And until then, I also welcome any students to interact. On my first slide, which I've handed over, is my Twitter feed. If there's any questions or follow-ups or discussions people want to have, including about India and looking at some of the activities and Supreme Court's lack of involvement, those sorts of things, we could discuss that happily. So I am absolutely welcoming questions and interactions. You've got my email and my Twitter, and I would love to hear from people in the future.
Thank you.
Thank you, madam.
Thank you all for having us.
Let us cooperate and jointly arrange some programs in future.
Yes, sir. Sure. Okay.
Thank you so much for the opportunity this evening, and I hope everybody stays well.
Yeah. Thank you all. Thank you, students, and we look forward to join you for the join us for the next session at 7:30. We have another session in the evening. So thank you all.